May please, Lordship. Lordship, yes, I hear the defect.
Then, Lordship,
Yes,
the earlier bail
remove
application
defect.
has to be disposed of, Your Lordship, being defective. Or she has to withdraw.
Yes, you have to withdraw.
Defective, Lordship. And Lordship has already passed the order, yes, sir.
No, in the sense that what you have to do is you have to file application, separate application. The other one would stand, dismiss.
Dispense.
Or
Dispose
withdrawn.
of, dispose being defective.
Because the earlier one cannot be taken, because that has already been disposed of with a direction that you file separate bail application. So what you should have done is you should have filed two.
I have filed two now, Your
filed
Lordship.
two.
I have filed two, yes.
We'll dispose of the other.
Lordship, only I have a small submission, Your Lordship. Lordship, this is the third time that the accused has come before Your Lordship for grant of bail. In two occasions, Your Lordship, Lordship was pleased to reject the bail.
Yes.
Lordship, on the first occasion, Your Lordship, on merits, and then the second occasion, Your Lordship, that in spite of the fact that a bail has been for grant of bail on medical ground, that also has been considered by Your Lordship and rejected, Your Lordship. Now same thing, Your Lordship. It is also same, Your Lordship. The medical report also includes are the one which had been already annexed in the earlier bail application, which Your Lordship had already considered, Your Lordship. There is no fresh, Your Lordship. Then going by the lower court order, it appears, Your Lordship, that the accused, Your Lordship, she changed her statement off and on, Your Lordship. Sometimes she will tell the trial court that I want the treatment to be done at Manipur. Sometime at Silsad at Bali Hostel, Your Lordship. We have and Lordship, also another fact also is that, Your Lordship, that it is not the prosecution, Your Lordship, who is to be blamed for the delayed trial, Your Lordship. The accused also is equally to be blamed, Your Lordship, for because defense counsel is not present, Your Lordship. So my humble and respectful submission, Your Lordship, considering the facts, Your Lordship, that Your Lordship was pleased to reject the bail application in the earlier occasion, Your Lordship, and there is no a change of circumstances, Your Lordship. My humble and respectful submission, Your Lordship, this application also are liable to be rejected, Your Lordship.
Yes.
Lordship,
Lordship, we have compiled the order, Your Lordship. We'll keep this, highlighting the relevant.
This is only with regard to her medical condition.
Lordship, yes. At one time, Your Lordship, she stated that she wants to be what is that she wants in Manipur. What is the order? 15. 15. Where is it?
Anyway, this is only with regard to the medical condition. That is what. What about what the court is more concerned is about the issue of delay in trial.
Delay, Your Lordship, as I have submitted, Your Lordship.
Do you have the copies with you? Relevant orders?
Lordship, in fact, we have
No, the trial court's order.
Lordship, yes, this is we are getting from CIS,
Oh,
Your
yes.
Lordship. Court CIS, Your Lordship.
11, 12. Let me see.
If Lordship, kindly go to this NDPS 11, which is the 64 or 65. 11 is in 64 or 65. If Lordship kindly see that special NDPS case 11, Your Lordship, the order dated 11/12.
11, 12.
NDPS 11 2022. The order dated 11/12/23, Your Lordship. The first order, Your Lordship.
Yes.
Lordship, kindly see the accused Kim Neko defense counsel is absent. Then if Lordship
Just a moment.
Lordship in NDPS 11.
Yes, of course.
The order dated 11/12, Your Lordship. Then Lordship, kindly turn to the next page. That is the order 15/11.
This is 11, 12, 2023.
22, Your Lordship. This is the order.
22 or 23?
11/12/23, Your Lordship. The order special are the NDPS case 11/23. The order dated 11/12, Your Lordship. Then if
Just a minute. Where is it noted that the accused counsel for the accused is absent?
Lordship, yes. Then
Yes,
Lordship, kindly see the next order, Your Lordship. That is the order dated 15/11. There also, Your Lordship, absent.
Yes, absent.
Then 1/11, Your Lordship, through BC, Your Lordship, this examination decline. Then if Lordship kindly come to the next order, that is 18/10/23, Your Lordship. Here also absent.
This one.
Lordship,
Yes.
order 18/10/2023, Your Lordship. That is also absent. Then 4/10, Your Lordship, that is also through BC.
But here also no, see, in all these orders, nothing has been recorded that the witnesses are present.
Lordship, that is correct, Your
Because the
Lordship. Going
witness-
by the order,
See, if there are many accused present here. Not
going
only
by
one.
the order, that does not reflect, Your Lordship. But
So what happened is, you see, if the if the counsel of the particular accused person is absent, the counsel of the other accused would be present,
Lordship,
as indicated.
it appears so, Your
And
Lordship.
since the matter is
Appears so.
fixed for
It
evidence,
appears so, and the order of the Land Trial Court does not reflect that whether the witnesses are present or not, Lordship. It's not
if they
clear.
are present, they would have been examined. And the cross-examination of the particular accused would have been reserved or otherwise not reflected here. There is no indication as to whether summons have been issued. No, summons have been issued. You just note this order dated 410. Mr. Shulai,
Lordship,
this order 410/2023.
410, Lordship.
Particular witness was summoned, but he is not ready, is not available on that day.
Just, 410.
Yes. No.
Already. Yes.
Afraid, miss, I think it is not as you have. It is not as you have presented the case to be. It is not. It is not an issue where witnesses were not examined.
In one case, 2 witness I have submitted, yes. And
Forget
in
about
one,
the other case. But even in this case,
Paraton I have submitted in one case, and one case,
okay.
2 witness.
But in this case, you see, if you notice the process for examination of witnesses, took place only, I think, in the month of October. All along, it was in the course of filing of the supplementary charge sheet and the FSL report. In fact, it was in August that the matter was posted for argument before charge.
After the charge sheet.
After charge sheet. So, the actual trial will proceed from the stage where evidence is recorded. Effective trial, I mean, see. So on 22/8/2023, matter is posted for argument before charge.
Lordship, yes.
5/9/2023, charges were framed. It would appear the charges, yes.
410 for evidence, Your Lordship.
And 410 fixed for evidence.
My submission was she was detained since 2022, yes, in this case.
That, of course.
Yes.
Detention is...
And the period of detention to be counted from the day when she is detained, Your Honor. The date of remand when she was remanded in the case.
She may have been remanded maybe, no, a long time ago. She may have been remanded a long time ago, but the fact is, when the actual trial commenced, it was only as recent as October.
No, in which? If Lordship kindly come to the order dated 22/2/2023. 22/2/23, Your Lordship. In NDPS 11. Where is that? 22.
Yes.
Lordship kindly 1, 2, 3, 4. Lordship kindly see paragraph 5. Accused Shimati. Lordship Ascodian.
Yes.
Is produced by a BC from July, and on being asked, she said being detained in prison, she will never feel well. Then Lordship kindly the as on 22 or 22nd to 23, Your Lordship, her medical condition is very stable. Lordship, that is reflected, Your Lordship, in the order. So, Your Lordship, the intention of the accused is that so long as I'm inside the jail, I'll never be well.
No, that is
Naturally, who will be well in jail?
Lordship, Lordship, this is the order passed by the London Trial Court, Your Lordship. She said being detained in prison, she will never feel well.
That is why she wants to get out of jail. We have to apply logic.
Her hand, yes. It's a fact that it need to be operated now. That Lordship may kindly consider, because Lordship has already
Lordship
passed the order also.
Lordship on 15/6, Lordship kindly see the order 15/6. 23, Your Lordship. She said, I want the treatment to be done in my own state. 15/6, Your Lordship.
See, Mr. Shulai, this court has only observed as far as treatment is concerned.
Lordship, that
It
is
would
true,
depend
Your
on-
Lordship.
it
But
would depend on
what I'm
personal
submitting,
preference.
Your Lordship, because the NACRIM, Your Lordship, NACRIM hostel, as the earlier, as was indicated earlier, Your Lordship, they are having their falsities. They can do that. It is not a serious, just to remove the plate from the left arm, Your Lordship. So they can do that.
It's a serious operation also, Your Lordship. And moreover, whatever my senior has pointed out, that absent and all, it was never delayed from our part, Your Lordship. The trial was never delayed because of us. The witnesses, if the witnesses are present, it's taken up. But witnesses
That
were
is
not
true,
present. That is, Your Lordship.
See, that is true. That even if this court would take that into account, as observed from the proceedings, copies of the proceedings are here.
Yes.
The process for examination or summon of witnesses began only in the month of October. So it's just 2 months, down the line. You can't expect in 2 months to get all the witnesses to come and depose. If, as has been, as this court has been made to understand, if it is so that witnesses have not been summoned for the last 1 year,
No,
then you have on that ground. I think initially this court has made that observation.
overall, Your Lordship, in the period that the accused person has been detained, overall, that is the submission which I Lordship has passed the orders. Kindly consider this, Lordship. I have cured the defect also. I run like anything, Lordship. Kindly in the process, even me also. Kindly, since Lordship has opined also
It
in
is
the morning,
only, like I
will
said, the
abide.
earlier order was passed. It's only based on the fact that the trial was delayed.
Lordship, because
And for that, this court would also have the backing of relevant orders of the apex court and Satendra and Anvil and other cases. But anyway, until
humbly pray, Your Lordship.
At most, I think we'll call for a medical report.
Okay, Your Lordship.
I've already passed it, or I'll just modify the order that was already passed. Om no to ka. Naka paragraph 7 mo. This court has considered. Should I to turn away the Leonard, this court upon considering the objection made by the Leonard AG as far as the presentation of this petition is concerned, wherein a single petition was filed in connection with two separate cases, wherein the accused person of name is accused person Srimati Kim Nicole Kongsai was involved in. The Leonard Counsel for the petitioner has submitted that she may be allowed to correct the defect and to file a separate application as far as the other case. That is, what is the other case number?
One is 64 and one is 65, Your Lordship.
65.
Period. Yes, case number 64.
The 65 is what is the trial court's?
In both the cases, she has been charged under Section 29 only, Your Lordship.
Case number.
11. Where is that?
No, this is just the PS case number 64.
Yes, that is the PS case number. 65 is criminal NDPS case 11 of 2022. And
No, the case number in the court record, Lordship, it in 64/6/2022, clearly at PS case number 64/6 of 2020, it is special NDPS case number 9/2022.
Yes.
And the other one is 11.
Then Lordship in Lordship correct, Your Lordship. 11, Your Lordship.
So you have filed a separate application as far as 11 is concerned.
Yes, Your Lordship.
Kuno to. Criminal.
In both the, no, I have filed both two bail application.
But what you have done is you have the later application is with regard to 11. Case number 11, isn't it?
In both 11 and 9, I have filed fresh.
No, the earlier.
Oh, you have filed fresh?
Yes,
With
yes.
11
Lordship. I have filed fresh in both.
Kuno to. Boleh biang? Em to na asuk tu. Pom no tu bro. Haka tu koi ka. So where is the original case record? The woman is no.
That is.
Huh?
What is the application number?
Fine. Sorry. This has become very confusing.
The earlier application.
So that the earlier case would stand as withdrawn.
Dismiss on withdrawal. Dismiss on withdrawal.
Dispose of defective, Lordship, being defective, Lordship. Lordship,
Lordship, according to her wish.
I'll pass this orders. To pom nak baro ngat sa pass tu ko yo. Ni kan nongka. Betul. I don't know. This court has considered the submission made by parties and has also referred to its order dated 17/10/2023 to say that as far as the prayer made by the petitioner on behalf of the accused on medical grounds, that is, the requirement for treatment of her ailment at the Valley Hospital, Silchar, is concerned, this court has made its observation at para 6 of the said order. However, the fact that the accused person is not comfortable with treatment given at Nigrims, but would prefer treatment at the said Valley Hospital, has also been noted by this court. This, at this point of time, cannot be given credence to. However, in the interest of justice, it would be prudent for the court to produce the latest medical status or condition of the accused person as to whether her ailment or infirmity, as the case may be, would cause serious impediment to her health vis-a-vis her incarceration in custody at the district prison. In this regard, the prison authority are directed to facilitate the accused person to be once again medically examined at Nigrims, and thereafter for a medical report to be filed before this court for consideration. It may not be out of place to request the Nigrims authorities to also give their opinion as to whether the accused could be treated at any other hospital other than Nigrims for such treatment, for such ailment. Having an implant, do you call it an ailment? It's not a sickness.
It's not a sickness.
It's not an
No,
infirmity.
it's not a sickness, Your Lordship.
It's not an ailment. What do we?
implant, Your Lordship.
Implant, Your Lordship. So suppose like I fell down, Your Lordship, there may be a
understand.
crack or a dislocation of the bone and all. Then just to
No, Your Lordship, it may
let
cause serious problem, Your Lordship.
No, that is understood.
Yes.
I'm not saying. You see, we are not talking about the seriousness or not non-seriousness of the matter. I would agree. Anybody with a foreign object in the body would have some discomfort. It would be serious in nature, but the only point is what do we call it? You see, do we call it an ailment?
no, it
we
cannot
call it
be,
a-
Your Lordship.
Infirmity, or do we call it a sickness?
It's an infirmity, infirmities and inside the bodies, Your Lordship.
It would be.
Troubling her and then, yes.
Anyway, I'll I'll consider what word to use. Kung to ko ta, kung tanay. For such an yeah, for the purpose of removing of the said implant on her left arm.
Your Lordship, Your Lordship.
Left arm. Next, on the contention of the petitioner that the accused is entitled to be enlarged on bail on the ground that the trial has been delayed for a considerable period. The learned AAG has produced relevant copies of the proceedings before the trial court, and on perusal of the same, without going to the details thereof, it would appear that charges were framed against the accused on 5/9/2023, and thereafter the matter was posted for evidence. As according to the petitioner, there are about 9 witnesses, 9.
In one case 9 and in one
In
case
this 11?
12, you know. In this 11, how much?
There are 9 and 1 is 11.
6 paragraph. 9.
9. 9, yes.
2 were
And
examined.
in 11 is,
2 were examined.
yes,
There
2
are-
examined in this.
There were about 9 witnesses, of which 2 have been examined. Next.
And in other case, 1 witness, yes.
9 in 65, Your Lordship, and 12 in 64, Your Lordship.
12.
Yes, Your Lordship. In 64,
Out
out of 12, 2 had been examined, Your Lordship.
of 12, 2 more. 11, not 12 more. As far as continue, as far as examination of the witnesses is concerned, it cannot be said that the case has been delayed unnecessarily on this count. The ground that the accused person has been in custody in connection with this case for about 12 months or so is not a relevant factor to be considered by this court, given the fact that due procedure has been carried out, and also considering the due procedure has to be followed, including filing of the supplementary charge sheet and the FSL report, which was acknowledged by the court in due course, and upon the filing of the said supplementary charge sheet, the accused person not making any objection to it. accordingly. The prayer of the accused, the prayer made in this petition will not be considered at this stage till the medical report is produced before this court. Let the said medical report be filed before this court within the next date fix. This is matter on 28th.
28.
So we'll see. Oh, I got to you. I take 20% on direction for you accused to be medically examined. Let the same be done so. Today is
20.
day after tomorrow.
Lordship, yes,
Please
we'll ask the jail authority to do the needful.
let the said medical examination be conducted on 21st.
Tomorrow is. Let it be on 22nd, Your Lordship, to be
22nd.
22nd, Your Lordship.
22nd. I think too. Fine.
In the next item, we'll follow only the number of witnesses, Your Lordship.
See
In
what
that, nine witnesses, one had already been examined, Your Lordship.
The court master or the PS will, if there's some clarification to be done, we'll just get it from you.
Lordship.
Sometime in the order
Lordship,
it becomes
yes.
confusing when there are two
Lordship.
similar applications. If Negrim says that yes, she's at liberty to go anywhere, then the very next day I'll give you bail.
Lordship.